Good morning. We are in Senate Judiciary. It's May 16th. We're going to be voting on the changes to the House regarding extradition procedures. It's S87. And heard a lot yesterday. What was discussed, the timeline has been left unchanged. The House provided essentially a layer of judicial review for a person if they want to contest the validity of a previously signed waiver, which I think makes sense. We did hear previous testimony about the concerns regarding the timelines, and the jurisdictional survey that was provided by our alleged counsel showed that, at least in my own opinion, that the 90 days up front with the 30 days after for an extension isn't a particularly unusual system. There's some states that have 180 days, some states that have no time limit at all, others between 30 to 90 up front. So I'm not particularly concerned about the timelines that we established that are unchanged. But that's my opinion. Before we move along, there are many other thoughts.
I mean, I feel differently about the timelines. I'm also looking at the jurisdictional survey, and maybe I just don't understand, but it clearly says under the federal law that no person shall be held in custody under telegraphic request, and I don't know what that means, for more than 90 days.
Yeah.
So to me, that would mean that we should not have a longer than 90-day time frame for proposing 120.
So, yeah, that would be for federal extradition.
Okay. But that's the uniform thing, right?
Yeah, the uniform code was established 100 years ago, almost, provided that 90 days was that keeping somebody detained keeping somebody detained at 90 days was not something that was proper. Not using the right spring.
I think I understand what you mean, but we are proposing someone could be detained for 120 days, so we're sort of wanting to fix that.
No, I don't think so. I mean, the norm is between 30 to 90 days. There are many states that have 30 days. And then following the 30 days, it can be either extended indefinitely or the person just gets rearrested and recommitted for another 30 days to start the clock over again. So I mean, anything, I think having the numbers strictly laid out makes the most sense rather than just saying, you know, you can have somebody committed for detained for 30 days and then you just rearrest them. You have somebody detained for 30 days, and you have the option to extend it indefinitely. I don't think that makes a lot of sense. But I think that the opportunity to have somebody get released on bail at the end of the 90 days is positive as well, which is already what we have.
I think moving into 90 days without the due process check at a shorter period of time is problematic. And I know it was for lacking the consent, just information we've gotten since that was made over that.
So if somebody, so there is a due process check. I mean, it's established in state person at bar. Well, I don't know if it's established or just reaffirmed in state person at bar regarding, you know, if somebody is not facing charges in Vermont, that there is an extradited offense. They can file a petition for habeas corpus. Somebody is facing charges in Vermont. They could appeal any hold without bail order under 13 BSA 7596. So I would say that there is a process with our current system, and the additional judicial reviews added by the House, it provides an extra layer of protection.
Yeah, I do support what the House did. I don't support what we did. Like yeah, it just doesn't sit well with me at this point in time.
Anybody else?
I'm okay with concurring with what the House did, the not exceeding 90 days, and also a judicial review has to be done if they want to extend that. And from what we heard testimony, the judge along the way could be like, let's get going here. So not exceed that 90. I'm okay with what the House did.
Bob? Senator Wise?
Well, such as I said yesterday, I think we sent them a good bill and they made it better. So I'm willing to concur with the House's rendition here.
Alright, well, entertain a motion to vote this out in favor of the.
Right, make that motion.
I don't think so.
So moved.
Call the roll. Any further discussion?
Senator Norris,
Yes.
Senator Bihovsky,
No,
Senator Baruth, Senator Meadows, yes. Senator Hashim,
Yes.
3-1-1.
I can report this. I think it's been on the notes. You have to take anything up the floor if it's just the current.
There is a form, you do have to bring it up, and they can give you a form from the Senate Clerk's office.
Okay.
I think you probably have to go as it came over from the House, right, or the amendment, I should say, they can just bring that back up.
The House proposal of amendment.
Right, yeah, exactly.
I get a clean copy of S87, the House proposal of amendment. That's yes. Thank you. And for witnesses on this round 2, heard from the state's attorneys, general counsel, governor, attorney general, defender general, election counsel. You hear from anybody else? Am I missing anybody?
Sure, it's available somewhere else.
All right. And move on. That's 109. Miscellaneous bill. We don't have that in our possession yet, but we're just getting a head start to hear the changes and decide what we want to do. We eventually get it into our possession. It'll be probably Tuesday or Wednesday of next week. Similar thing with S12, and just a housekeeping thing. It says possible vote on the agenda. I think that was an error on my part where we can't vote on it because it's in the House. So we're just waiting until they vote it out. Most likely take it out. Fair North?
Yes. I get an appointment in 25 minutes. Do you need me any longer here? You still have a quorum?
Yeah, we got it. Oh, no worries.
All right. Thank you.
Good luck.
Thanks.
Eric, floor is yours.
Thank you. Morning, everybody. Eric Dispatch with the Office of Legislative Counsel here, as the chair said, to start looking at with the committee the changes that the House made to the aid and miscellaneous bill S109. As chair mentioned, the bill is not here yet. Actually, has not hit the House floor yet, but it is scheduled to do so between 9:30 and 10 this morning. So I only have a relatively limited period of time. When that is for, I'm going to get a text and go. But I can try and get through as much as we can. And so I may end up talking quickly. Feel free to slow me down. I have a tendency to do that anyway, but maybe it's faster. So I noticed this anybody and sent this out. Does everybody have a hard copy with the highlighted version? Oh, you do? Okay, that's fine. Excellent.
3:35 p.m.
Yeah, exactly. And as is frequently the case, the changes made by the House to the Senate are in yellow highlights. So for ease of reference, I won't review the stuff that wasn't changed. So that's works okay for everybody. And they really didn't change much of what you passed. They added, you'll see they added a lot on the back end as to what you passed. There's only a couple of changes. Relatively minor. The first one's on page 6. And now this is section 10, and this has to do with, you remember you guys passed this section which had to do with the Victims Compensation Board and asked, and it's this idea that when not only can crime victims apply for compensation, but interveners, what's called an intervener, can also apply, and that's somebody who tries to assist a law enforcement officer in the course of a crime. They kept that part, and what the House suggested, I think it was at the request of the Center for Crime Victim Services, was to expand that not only could the intervening be on behalf to assist a police officer, it could be to assist one of the other protected professionals that are defined currently in, that's, you may recall, where that definition sits, is you have heightened assault penalties for assaults of certain protected professionals. So you have a list in that assault statute, which is cross-referenced here. It happens to be law enforcement officers, firefighters, healthcare workers, DCF employees, emergency medical staff. So if you intervene on behalf of one of those people, in addition to a law enforcement officer, you could apply for compensation. So that's this most change.
You recall what the Victim Services Center, the correct name is escaping me, but Center for Crime Victims. Yeah, you recall what their thoughts were?
Yeah, their thoughts were exactly this, to expand the scope of professionals who might be getting assistance from a citizen who's trying to help out in commission crime, so that the person assisting one of those folks who might be involved in criminal acts could also, that's not a guarantee of compensation, they just have to apply and found to be qualified, but they would at least be able to apply. Yep. I think the only other change to what you guys, well, no, one other change was,
That's
But I think Eric has to leave in 10 minutes. Okay. Okay, we'll leave in 10 minutes, okay. I need to
stay
do
local. I can say whatever you want as far as what I have to leave it. I'll stop. But I may have to leave it then. Who knows? Depends when I get this text from upstairs. But like I said, I can move pretty quickly. So section 12, you see is struck. Now, the reason that's struck, is because it was passed and signed by the governor yesterday. It was in a different bill. It was in S9 that you guys passed. So that's the only reason. No reason to have it twice. And then they made some changes to it. You guys had, you may recall, this is over, I think, on page 17. Well, sorry, one over on page 16. This has to do, you remember the section? It has to do with records in the chain of title that are in the town clerk's office.
sorry, what page?
Page 16. But it's related, so you'll have to look at page 15 as well. And it's this idea that it's in existing law. You folks added one additional way to do this, but it's when you have certain records that have been in the property chain of title for a long enough period of time, usually 15 years, that nobody's challenged it legally, then it's validated essentially. For example, if there's an error that something, well, the one that you added was, for example, a document that's in the chain of title that says this was executed under a power of attorney. Well, under the law, the power of attorney is supposed to be there too. But if for some reason it was neglected to be filed, nobody ever challenged it in 15 years, then it's deemed valid, even though it wasn't. That's what was added to this other list of things. But so you look at line 14 and 15, page 15, this is the existing law, and one of these other instances makes clear to say this subsection shall not apply to a power of attorney that's obtained by fraud or forgery. So that's kind of an out saying, well, look, generally speaking, sure, we can validate these documents that are in the chain of title after a certain period of time. But if it was fraud or forgery, that is how it ended up there, then you don't validate. And so all the House did was add to that exact same line, to the new provision that you had. So again, just the same concept that if this was fraudulently done, well, we're not going to all of a sudden say it's okay. It's supposed to be checked. So that's that little change. Okay, another one you'll see on page 17. This is both sections 23 and 24. That had to do with the public inebriates. Remember that was this. Say it again, sorry.
That's the repeal. Right?
Exactly, the repeal of the repeal. So that as of this year, if this had stayed on law, then public immigrants would not be able to be housed in DOC facilities going forward. But you already passed this. This is a similar thing. It's passed in S-36 and it's with the governor right now. So actually, now I think that this was signed yesterday. So this was also already law. And the sections 22 and 24 were signed in S-36 yesterday. So again, nobody's had a choice. Next section, page 18, section 24. This is the firearms surrender order compliance working group that you guys created in here. They made some changes to it, really primarily technical, kept the general big picture of what the group is and what it's studying, this sort of this uniform process to ensure compliance with firearms surrender orders. It doesn't create any new circumstances under which firearms can be surrendered, but applies to there's different places in existing law and relief from abuse orders, extreme protection orders, assault charges, that sort of thing. Firearms can be ordered to be surrendered under the existing law. This is just trying to have some folks get together and develop a uniform process for how to handle those situations.
Quick question are the yellow highlights, are those things that the House added? Or shot? Or,
Yes.
yeah, so they added the membership piece?
Well, this is the one, no. So this, like I should have said, sort of the one exception to the question you just asked is this one. They made so many splitting changes. I just highlighted the whole thing just so I could then explain it to you. So no, you guys had the membership piece in there, but in your version, it had 16 members. So they cut the membership back a little bit and instead created over on page 19, line 8, a list of consultees.
Yeah.
So they broke the group up into that. Some make the membership smaller, but put some people, instead of being members, they would be required to be consulted. And the folks that were moved to the consultee list, you look at page 19, were number 1, the Commissioner of Corrections, number 2, family law practitioners, and then 6 through 10. Alcohol, tobacco, firearms, medical society, mental health, victim services, and domestic violence. So those were on the working group beforehand. Now they're in the list of consultees.
My first reaction to this is the consultation. I mean, and I know we've had it in other places where we just kind of leave it broad and just say, working group can consult with whomever they need to consult with the understanding that they have, that are going to be reasonable and seek out other stakeholders that are relevant. So I don't know that we necessarily need to have this long list of people that they can consult with. It just seems unnecessarily prescriptive. I'm also not sure why they crossed out law enforcement.
They got moved up to into the list of members. So if you look at 8 and 9 of the actual membership, state police chief, they got moved into the working group rather than being the council's list. The host group.
So I've certainly seen us do this both the way you described, where it just sort of says consult with who you need to. I've also seen us do it in this more prescriptive way. What I'm curious about is if the individuals that were taken from the list were consulted with, because I have concerns about removing like the network and mental health providers. I think they're pretty critical in the conversation about this type of issue. So I'm just really, I guess I'm curious if the House consulted with them about removing them and turning them into consultees.
It's a good question, and I wasn't there for all the testimony, so I wish I could give you an answer, but I can't. But it's a good point. But the only thing I'd add to it as you think about what you want to do is certainly there's no, wrong answer here. So wherever you can see like would be a better policy. But if you choose to, you can also add a notice, because sometimes there is language, as you were saying, Senator Ashik, and then I'm not sure why there isn't in this case, maybe just an oversight on my part. But sometimes there is language that says, and any other person in the community needs relevant. So you could also add language like that, list of consultees, or have that instead of a list, either way.
Well, it is my understanding, and I think we just talked about it with Tucker yesterday on a different bill, that anytime you make a list like this, it's not exclusive. Like they can consult with other people, it just they have So these people.
Yeah, you're exactly right. I should have caught that. So lines 8, 9, 8, 19. If you use the word, it all depends on how it's phrased. But yes, in this case, you're 100% right, because the working group shall consult with stakeholders, including, and the statutes have it in their general terms of definition, the word including is defined to be a non-exclusive list. So it's including but not limited to the sort of, you can think of the implied, because now we don't, when people try to add, well, shouldn't we say without listening to? We always say in our office, actually, you don't need to say that now, because it's defined that way throughout the sections.
I would want to hear from the groups that have been involved.
Like, I'm just reading ahead here, like, well, they snuck in the, very substantial change, the bail revocation, adding, people, but that's you, but that's just me reading ahead.
I was like, we're not
I was
talking
on
about.
working. Yeah.
Yeah, that's, so anyways, sorry, Eric.
No,
So,
that's okay.
continue from,
Right? So the Commission for Fish and Wildlife, top page 20, that person is new, just so you know, that was actually a recommendation from the House of Ropes. They were going to money piece of this, which you see further down on page 20, because there's a little money involved, because there's compensation for non-government employees who are that work. So move on to the next section, unless there's, okay, so the next one was a House bill to start section 25, it was H7. That's, and this is actually connected to, you may recall this last year in the miscellaneous bill, in this bill, at the very, toward the end, there was at the request of DCF, there was some language that was repealed that would have said, actually, the language that was repealed is being reenacted. And that's on page 21, lines 14 to 16. That was in statute up until last year. The idea is that someone's failure to make child support would not be considered in the context of a TPR, termination of parental leave. The idea that DCF was saying was, a person's poverty isn't relevant to the decision of whether or not their parental rights should be terminated. However, because of the place that this language was in, it didn't apply to those situations where DCF, where you think of a more common TPR situation, it applied in a contested adoption proceeding between parents. For example, the divorce case where we're talking about child custody, one parent wants to adopt, that sort of thing is where it did apply. And it didn't actually apply to DCF termination situation. So the proposal here is actually the next three sections in a row are all connected. Proposal is put the language back in where it was repeated. Because what happened, who noticed this was a bunch of family law practitioners who said, hey, that's actually quite relevant in situations where parents are disputing the custody of a child, which parent should have custody. If one of the parents has failed to make child support payments, that might be a relevant factor for the court to consider as to which parent, whether adoption should be permitted to proceed. DCF agreed with that, and then said, but we want to make sure that in DCF TPR situations, the child support payment history can be considered. So that's what you see on the next page, sections 25A, 25B. They propose, so they've all agreed to this. The DCF and family law practitioners agreed. Put it back in the adoption section of law on page 21, but make clear in the TPR termination of parental rights provisions of law, Title 33. In those situations, DCF's Family Services Division can't consider child support payment as a factor in the determination of parental situation. So that's the compromise that they came to.
I'm understanding what we did last year wasn't quite what we meant to do.
I think that's an excellent refixing of it.
Okay. I mean, I am a little curious as to why someone's poverty would ever be an acceptable consideration for taking their child away, but I do understand that last year we didn't do quite what we meant to do.
Yep, I think that's the idea.
I agree, though I see that even in accordance with the respondent's financial needs, and I think that as the opposing parties provide evidence and say you have a situation where somebody is quite wealthy, but just out of spite, they're choosing not to, not make payments versus somebody who can show that they are unemployed or they don't have financial means. Show that they would be making payments, but they just can't. I think the court with this language could consider that. Okay.
All right, so, next section was a House bill, section 26, was H 108. This, repeals the criminal penalty for failure of an adult child to support a destitute parent. An ancient statute that is still on the books that was changed, found by a constituent of a House member, pointed it out. So that's interesting. No one has any recollection of it ever being prosecuted. But it's quite old and seems as it's not really. Although some of us who are older might like to be able to enforce that if a child has to pay sport, but I think it's probably. That was at least the thing. Archaic, not used. All right, so sections 27 and 28 are also, those also actually were in the budget that's already been passed. So that was the thing you maybe call it repeals the sunset on the increase in the marriage license fees that was passed in 2023. So that is also started now. I think the budget is also approved that to be signed. So that's was here just in case it did pass through there, but it didn't. All right, so now I think we're moving on to the same one that Senator Hashim just mentioned. This is section 29. This was in a House bill, H 409. It permits the prosecutor to appeal a court order that when there's a motion to revoke bail by the prosecutor and it's denied. Right, so the prosecutor finds a motion on revoke something this person did, maybe they violated their conditions, whatever it may be, and it's denied. It allows the prosecutor to appeal that order the same way that they can appeal a release without bail or a conditional release order current. So it basically pulls it into existing procedure under subsection C1 on page 25. So right now, when a person released, whether without bail or other conditions for release, you can take this appeal to a single justice of the Supreme Court. They can either hear it themselves or they can refer to the entire Supreme Court. Their order is final; it can't be further appealed from there. So that process that exists for releases without bail or on conditions of release is applied to this new different situation, which is when a request to revoke it is denied.
And so is that just using the same standard that defense attorneys have to use when appealing a hold without bail action, just abuse of discretion?
Yeah. And of that whole existing abuse of discretion, how, whether it's heard by a single justice or whether they refer to it, all that stuff is, this is tacked onto that. So
They get much testimony on this? You don't know.
yeah, I'm not sure.
Oh,
But I can follow up.
that's okay. I was just curious.
Yeah.
Because it's a big change. Anyways, please.
Yeah. So that was that one. Okay, so now we're over on to section 30, page 26. This is a request from the Center for Crime Victim Services. It concerns victim notification procedures with respect to the earned time program. You may remember, so the earned time program, basically the way it works is that it's for every 30 days, you can earn 7 days off. The maximum if you haven't gotten any violations or you haven't been any subject to any charges, that sort of thing. So it's a procedural thing. It doesn't change any of that. But the way the system works now, whenever an offender gets any earned time, this is under subdivision B, page 26. Whenever an offender earns earned time, they get notice every 90 days. So they get notice of any earned time that they earn. So this allows the victim to opt into that notice as well. They don't have to do it. They don't want to, but they can choose to get the same kind of notice every time that the offender does. So that way they find out the offender in their case is getting confined, which might result in early release date, which is covered as 27, they also get notice that they opted of any changes to the vendors and release date. And that's really to change language. That's still existing. Next section will also require, sorry.
So the current law is earned time comes off the minimum sentence. That's I see it under.
Yes,
So
exactly.
okay.
And speaking of victim notification, Section 31 also requested by the Center for Crime Victim Services. This is just a task force to look at, as I said, also a request by the center, also to look at the responsiveness of the victim notification system in general. Well, there's many places in law where victims get notice of stuff. We just looked at one. The earned time is one, but it's also they get notice of proceedings so that they can go and make a victim impact statement if they want to. So there's various places in law where they're entitled statutorily to receive notice. This doesn't change any of that. The idea is to look at that process and see if, particularly with respect to automated notification, whether or not there are improvements that can be made to make sure they are having the accessibility to information that they should. So that's the idea. It's a task force with a number of members. Sort of the essence of what the task force is supposed to do is over on page 28, lines 5 to 12, study the current state of Vermont's victim notification system, including improving victims' accessibility, ensuring that it's trauma-informed, expanding use of automated notification systems, and recommendations for any necessary training for systems. There's a report back in December of this year.
I'm looking ahead now. Looks like there's like 6 task forces in here. I think we should rename the bill of act related to Judiciary Task Force.
Has anybody ever killed on this line?
Like, this is ridiculous. Anyways, sorry.
You could always rename the title. That's always an option.
I'm a little tempted to send it back to them with that.
Speaking of which, next section, the adult and voluntary guardianship working group. This one, actually, you may recall there is a connection between this one and a bill that you heard testimony on. Actually, not so much testimony, but maybe testimony. A bill you may remember from Senator Williams. Yes, and it's a constituent in Rutland County that's been advocating on this issue for a long time, which is the perspective that because there are 2 different types of proceedings for adult guardianships, 2 different courts. If it's involving an adult with disabilities, then it takes place in the family division. If it's other adults that not because of a disability, but are otherwise unable to appropriately care for themselves, that's in the probate division. So the option to have a voluntary guardianship only exists in the probate division proceedings, not in the family proceedings. And you may recall that's what Senator Williams' constituent was concerned about and had been concerned about for many years, and had been asking and actually specifically requested that the family division guardianship statutes be amended to be on parity and consistent with the probate division statutes, and especially with respect to the issue that I just mentioned, so that voluntary guardianships be available in the family division as well as the probate division. So this proposes to study that exact issue. And this actually was requested by the Probate Judges Association. And they've heard about this issue too. And they are in agreement that it's a legitimate one to look at. So basically what this working group is going to look at is kind of what I just said. Should these 2 different proceedings involving adult guardianships in 2 different courts be consolidated into one court, right? Or should they remain separate, but should there at least be statutory changes to make sure there's parity, so that they can both have the option for the same source of alternatives?
You said this was requested by the probate judges.
Correct. Correct. So that's that. The next one, okay, so the next couple of sections involve the process for when assistant judges request capital funds for county courthouses. You know, most of the courthouses, not all, but most of the courthouses are owned by the counties. When the county officer, the assistant judges, wants to make capital improvements to the courthouse, there's this statutory process they have to go through. And what they have to submit the request to the court administrator, and the court administrator evaluates the request on the basis of these listed criteria. And on the basis of their evaluation, they then make a recommendation to the Commissioner of Buildings and General Services as to whether or not that request should be included in the governor's annual budget request. All right, so that's all existing law. That's the way it is. What the proposal here, and I should mention that this came from the House Corrections and Institutions Committee, who took a lot of testimony on this from both the court and the assistant judges. And both those parties are in agreement with this approach. So what they agreed to do was add a few criteria. Remember I said, so there's a list of criteria the court administrator has to consider when the request comes in. So it adds a few criteria, 1, 2, and 3, that's the bottom on page 32, excuse me, and top of page 33. Whether the funding request is consistent with the capital program. This capital program is not required, it's discretionary, but they found a factor that the court administrator might like to know is, do you have one? You know, is this capital request part of your capital program or not? So they have to say so.
I object. Be respectful of both of your times. Do either of you need to go yet? Because you just chanted. Okay, that's fine.
I'm sorry.
We can still, if you don't have to leave, we can still hear from you.
I think I'm good. I haven't got the text yet.
We just can't suggest any changes or make any policy decisions. Sure. So we don't have a forum. So yeah, we'll keep getting the walkthrough.
Yeah, at least you're familiar with it that way.
Yeah.
Right. Yeah. So this has to do with that, as I say, this process when the assistant judge asks for capital funding requests for their county courthouse, and then add some criteria that the court administrator has to consider. And the second one on the bottom, page 32, is whether the project that they're asking for money for has been included in their list of capital budgets in their county budget. Because remember, that's a separate county budget. They have a county budget, and they have this. They might also request something to be in the judiciary's general budget. But this says, well, okay, so they want to know, hey, was this project that you're asking for from the general fund, was that in your county budget too? So it's just another fact that would be helpful for the court administrator to know when they're making this recommendation. Last one to add to that list, top of page 33, another optional, not required, but optional thing that each county can have is a capital reserve fund. So again, they thought would be helpful for the court administrator to know, do you have a capital reserve fund? And if so, how many, what's the state of your contributions to that fund? That's the capital. And in fact, as I said, they took a lot of evidence on this. Many counties do have these capital reserve funds. Many of them have much more money than other counties. And so, and some of them have had to spend a lot out of that because of the flood. So there's been, and all this testimony, all that, there was a lot that was in-house corrections. There's was in judiciary, but then proposal was to put it in this other judiciary, as it's actually in the judiciary title of the law. So I should mention about that section I just described though, delayed effective. Doesn't go into effect until July 1st, 2026. And in the meantime, page 34, section 34, there's a report. So that's the idea, that before it goes into effect, the court administrator, in consultation with the Association of County Judges, are report back on how it's basically a status report on how they're making progress on including these new criteria in their funding request for the government. So, as I said, the court administrator and the president of the assistant judges were all part of this discussion, and they're all on board. So, that's the question.
Is that necessary? If you're just adding a couple of questions up there. Evaluating the request, is a report really necessary that you have 3 questions?
But just switch out the word report with email. And if anybody's curious, they can just send the court administrator an email and ask about the progress.
Because I would rather see their time spent on actually implementing that, working on it, and not having to worry about a report coming back.
Also, that's a joke about putting in the word email.
I'm aware.
But yeah, but just for the record.
Yeah,
Yeah, but also we can't recommend changes right now. So
No, I'm
just a note.
Yeah, just a note.
Just a note.
Right. Yep. All right, so that's the gist of those two sections. Next section, section 35, bottom of page 34. This was H 490 in the House, so it was bill concerns penalties for DUI second offenses of DUI. Currently, the penalty, which is maximum 20 years, not more than $1,500 fine. Specifically, this doesn't have anything to do with that part of the penalty, but this is very bottom of page 34. Under existing law, of that penalty, of that whatever it is decided by the court, at least 200 hours of community service has to be performed, or 60 consecutive hours of imprisonment. So it's got to be one of those two things: 200 hours of community service or 60 consecutive hours of imprisonment. They're finding that they're trying to incentivize the community service option here because the feeling was that people are choosing the 60 days as consecutive service or 80 hours. Sorry, 60 hours. Thank you. Big difference. Because it's quicker to get completed, and so they wanted to incentivize community service option, so they dropped the 200 to 80. So the option would be now be 80 hours of community service or 60 consecutive hours.
80 hours,
No, 60. 2.5 days.
2.5 days in jail versus several weekends of community service.
Yeah, I think that's about right.
So more people take the 2.5 days to go to jail
Yeah,
over the community service, right?
Over 200 hours of community services. So that's a lot.
right. Right, there's a lot, but yeah, that's why we bought it down, trying to see if maybe make it a little more appealing for people. That's like 5 weeks, right?
Yeah, and it's obviously cheaper to have somebody take it voluntary route, right?
Yeah, so
Than incarcerate somebody for 60 hours.
And I add that about that though, is that that one has a 3-year sunset. So if we look over on page 35, line 5, it adds so the idea is, and I'll give you a quick up to speed on the center of house speed, because in a couple seconds, their proposal here is to, for current DUI second offenses, this is on page 34. Currently, someone gets DUI second, it's got a maximum of 10 to 20 years of jail, but and no one did 20 years for that. But the idea is that under existing law, you have to do either 200 hours of community service or 60 consecutive hours of prison current. So whatever they get sentenced to jail-wise, it has to include one or the other of those two things. But they're finding that people are not taking the community service option. Many more people are doing 60 hours consecutive to jail, both because it's to be completed a lot more quickly than 200 hours of community service. I think that's the main reason people are shooting. So the proposal was to incentivize people to do community service a little more, so they dropped that 200 down to 80. So
Yeah, that's a pretty big discrepancy, 60 versus 200. That's
For sure. Cool.
yes, but they want to see if this works, so that's why it's got a 3-year sunset. Over on page 35, lines 5 and 6. Gonna give it a few years to see if that actually works.
I'm becoming more and more hesitant sunsets in general, I think just because, something's an issue. And creating sunsets just creates additional work in the future if it's not something that's, life or death situation of critical importance. And I don't see that going from 200 hours of community service to 80 hours is, going to be anything that breaks the system. Something. But
anything I would imagine it would ease up on the system because there's no Yeah, I think I agree with you about the sunset. If there's a problem, we can come back and change the law.
I don't know what that problem would be. Too many people are taking
Right. Too many people doing community service. Oh no. I
That's-
agree. The sunset seems silly to me.
so another one that
Are you jumping ahead again?
I'm jumping a little bit back. It's that report section 34, which jokingly said to just be an email.
Oh, yeah.
That's one we can. I'm just making notes about things we can take out in the future once we actually have a session.
Isn't this on?
Sorry.
Is this one on the floor today?
Yeah, that's why
This
this
is
is
what-
what they call me, exactly. They haven't supposed to be on the floor.
Or must still be doing announcements.
I think, trust me.
They
And
might
it's not
still-
first.
I told you, oh, not
It's
first.
not first, I think it's third, so it all depends how quick they get through the announcements, the other two bills.
I mean, if we're changing things, and I feel like a little cheeky, I would like to change the name of this bill.
Yeah.
Completely an option, this will be not.
I know.
There's a lot added to this bill that's beyond this thing, this changes. But that's super things. Like, I mean, I feel like there's gonna be some testimony we're gonna have to get, definitely, so we are gonna be meeting next week for in the morning, 9 to 10. Here and there, just to deal with S12 and this and that. But anyways. Yeah, it's just here.
Yep, and toward the end is when things get added. So, yeah, I'm making suggestions, but there's always a few. You can delete or add this, the station things already, supposed to. Or both. That's the strange. All right, so I think there's two sections left. Section 37 is, there's some testimony that having to do with family forensic evaluators, and these are our mental health professionals who conduct evaluations and provide information regarding child welfare and parenting matters to attorneys, judges, agencies. And there was some testimony and concern that there aren't enough people doing that work, and there's a bigger need than there are people to do it. So the idea is to ask the Chief Superior Judge, Director of OPR, and the Executive Director of Vermont Psychological Association to look at that and see if there might be a way to increase the number of people. That's it in a nutshell.
Get any testimony or make any of the members say that they had already reached out to the Chief Superior Judge, OPR, and the Psychological Association,
Yes.
and did they decline to collaborate?
Yeah.
So we have to put it in law.
I would only say that this particular one happened, I was there for that one. And they said they happy members. They didn't say, answer your other question, which is what if not in law, which you're used to do it.
Yeah.
So good question.
So
That's worse than the email.
you're talking about 37?
That's the
Yeah.
name of the bill. Naturally,
That's
bills.
So would those requests be in the form of a report or an email? From the chairs?
I think, again, policy decision, but if I remember correctly, recommendations.
So an email.
Could be even, well, no, because it's November first, I was gonna say you could do this, because sometimes you say, the recommendations may be in the form of oral testimony. Once in a while, if, you way to write a written report, you can say, hey, we're gonna hear from you next January. Guys won't be meeting before the first.
We might be.
Right.
And, all those things as well.
All right, last section, a task force. This one, I will say, the Chief Justice is very interested in this one and has volunteered to be the chair. And this one has to do with looking at representation of children and parents in legal proceedings, in particular proceedings where children and families are involved in CHIDS proceedings, children need care supervision, or substantiation of abuse or neglect. So the idea is to look at whether or not the current system is sufficient, adequate, does it need some changes? Might there be changes, and this is over on page 37, might there be able to leverage some federal funds by making certain changes? And whether or not there might be interdisciplinary model representation that would work better. And then report back over on page 38, you'll see any necessary reforms to the legal representation system for children and families who are involved in CHIDS proceedings, or substantiations or abuse and neglect. So, and possible reforms they could recommend, and any proposed legislation to implement those reforms in this committee. That's about fair human services as well.
My face.
That's the last one. That's of course is. Oh.
Do you have any task forces on our home examples though?
Yes,
So this is S1
as, and is, a version of it that shows the changes that have been made by the House, or, yeah, presumably it's on the floor very shortly this morning, so if they don't make any further amendments on the floor, this would be the one that shows all changes made by the House.
Okay, just wondering on page 12, this is just changing the reference. You're facing firearms here.
Yeah, exactly, they had it inaccurate,
And that wasn't changed.
right?
Okay.
So I think that's stuff of it.
Regarding, failed reputation, yeah, we could go that, you know, that the stuff's in change. So just section 29.
Yep.
And suggest if it starts on page 24. Just for the committee, could you walk through the appeal process for, release or, failed reputation denial? And just what it means when you're trying to appeal based on the judge's discretion or abuse of discretion.
Yeah, I think that, so it's the abuse of discretion standard, as you said. So in other words, it's not that, when you appeal based on that standard, it's often said that it's was the decision below, supported by the evidence. So it's not whether you as the, say the Supreme Court justice sitting on the appeal would have made a different decision necessarily. That's not it. Well, I just viewed the same evidence and say, well, I wouldn't have decided that way. I've decided this other way instead. It's whether or not the decision that was made is an abuse of discretion. It's so far beyond what the evidence suggested that it amounts to an unreasonable abuse of discretion. So that it's really not just, in other words, the decision that was arguably wrong, that the appellate body looked at view differently. It's that it has to have been an actual situation where the decision itself was so wrong that it amounts to not a proper exercise of discretion, but an abuse of discretion. So it's sort of a matter of degree to look at this. And that's the standard that applies, as you said. And it doesn't actually use those terms, but it's another way to phrase that is it's in line 8, page 25. So if you appeal that order existingly, it shall be affirmed if it is supported by the proceedings. So that's the idea. It's not that you would have decided differently. It's that, hey, if there's evidence that would support that, then it has to be affirmed. And that's another way of saying it's an abuse of discretion. Yep. All right. Perfect timing.
Good timing.
Yeah.
Left us with some stuff to think about.
Yes.
And yeah, thank you for the walkthrough.
Yeah, definitely. And any further questions that come up, or you want to talk about any of the sections? And more important, if they make any changes on the floor right now, I'll let you know. If that's what we look at as a big different further down the road.
Am I reading it right that they added like 3 task forces?
Like 5 or 6.
Yeah.
I have made the suggestion that we actually rename this bill to an act related to judiciary task forces.
Yeah, that's a little over.
It's an idea.
Yeah.
It's an idea.
Try to track that up.
We'll have some more committee discussion.
Okay. All right. All right. Thanks, everybody. Yeah.
Thank you.
Yeah. We'll see you soon.
Voted out that's 87, by the way, so
That's an extradition.
no changes. And so for S 12. That one it's technically not in our jurisdiction. So, yeah, taking votes on it, obviously, but I think we will be likely getting it on Tuesday or Wednesday next week.
Is it S12?
Yeah, yeah.
How is it not in our jurisdiction?
They have,
We don't have it.
Oh,
It's still in the house.
yeah, or it's not in our possession.
yeah, it is in our
That's-
jurisdiction.
Yeah, it is 100% in our jurisdiction, not in our possession.
Okay.
So we'll get that Tuesday or Wednesday, and I think instead of spending time sending a further proposal of amendment, it just makes sense to go straight to the conference committee. So that's most likely what I'll ask for whenever we get it, and just get to it. But before we do that, obviously, we'll try to establish what most of the different goals are. Get that in. Any other? So we've got, oh yeah, there's S105. That one we voted out, and there were a couple of technical changes that were proposed by Judge Zone after we voted it out. So Ben will be coming to us with a proposal of amendment draft sponsored by me. I will present it to the committee and walk through some of those changes. They're not particularly substantive. There is one that regarding the automatic suspension for a driver's license. There's no procedure to appeal it, which currently does exist for driver license suspension. So we're adding a appeal process to that. I can't remember the specifics off the top of my head. Then we'll be able to walk us through it in a minute. I think we're gonna get that on Tuesday. I think that is essentially everything that we have to do this session. Am I missing anything?
What happened to S44? Is that not that?
We went to the government, right?
That's where it went to the governor.
Oh,
It
okay.
hasn't been signed yet.
We did that already.
Yeah.
Okay.
They just
They didn't,
conferred.
okay, they just.
They didn't make any changes. They conferred. They did pass the confirmatory adoptions and standby guardianship bill. I don't know if he signed that yet.
Seems like it's almost out on S14. They delivered it to me.
On the 15th. Today's the 16th.
So yesterday.
Really?
They delivered it.
I thought a few days ago.
What's the timeline? Because doesn't it,
That was
isn't
5 days.
he allowed? I have, it's 5 days for,
And it's 5 working days. Thank you.
Trying to look it up.
For the legislative.
Website, yes, varies some of the other. Yeah,
Yeah, delivered to the governor May 15th. So,
oh,
To me, that's gonna be really crazy if you get to that. Because all it does is put all the power in this hands. And then you always do anything that lessens the power in his hands. Then he'll be saying, doesn't matter which way it goes.
well, I mean. I don't know that would be entirely out of character.
Also, just got an email from Jen Coleman. Probably watching this right now. She can come in and testify on the sections that have been added, section 10, 29, 30, which and it says that she was the proponent of the changes that we see to 10, 29, and 30. We're talking about S109, by the way.
Yeah.
Sorry, I'm bouncing off of what's.
I was serious for voting some of these tasks.
Yeah.
Like, it's like over the top.
Spreadsheets, 10, 29, and 30.
I don't know. There might be a typo, but 29 is the fail revocation. That's. She's referring to the active notification for victims to get notification about their earned good time. And the task force with victim notification,
So that's 31.
31, yeah, and then
30 is the earned time reduction. Okay, so she must have meant 10, 30, and 31.
yes, and 10 is the expanding the group of first responders.
Yeah. Okay.
So she offered to testify, I don't know if she's still alive, but I did just get the 4 amendment actually, that for H105. So I was just discussing, you know. Steve can come in now instead of my internet, we can go off for now, by the way. And if you see if Ben could come in within the next